This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
I'm Shane Carper, and today I want to discuss the U.S. Supreme Court's decision DC versus Haley. The case was decided back in 2008, and it fundamentally changed how the Second Amendment is understood in American constitutional law. The facts of this case are straightforward, but their consequences are enormous. For many years, D.C. enforced some of the most restrictive gun laws in the nation. Under those laws, residents of D.C. were prohibited from registering new handguns, which effectively amounted to a near total ban on handgun ownership. All the rifles and shotguns could lawfully be owned. D.C. required that those firearms be kept unloaded, disassembled, and secured by a trigger lock. Those restrictions applied even inside the person's home and even when the firearm was kept solely for self-defense. In this case, Dick Heller was a special police officer in Washington, D.C. While on duty, he was authorized to carry a handgun to protect the federal building. When he was off duty, however, D.C. prohibited him from keeping a functional handgun in his own home. So Heller challenged D.C.'s law, arguing that it violated the Second Amendment to the U.S. Constitution. Heller's lawsuit was initially dismissed by the federal district court. At the time, most district courts interpreted the Second Amendment as protecting a collective right connected to militia service, rather than an individual right to possess firearms. The U.S. Court of Appeals for the D.C. Circuit reversed that decision. The D.C. Circuit concluded that the Second Amendment protects an individual right to possess firearms, that the right includes possession for personal self-defense, and that the district's handgun ban and storage requirements violated that right. The District of Columbia appealed, and the Supreme Court agreed to hear the case. For the first time in its history, the Supreme Court agreed to directly decide whether the Second Amendment protects an individual right to keep and bear arms, independent of militia service, and whether a complete ban on handguns combined with in-home firearm restrictions violates that right.
The Second Amendment must be read as a single, integrated provision. Its opening language concerning a well-regulated militia explains the scope and purpose of the right that follows. Historically, firearm ownership has been subject to extensive regulation, and the district's law represents a reasonable response to severe gun violence in a densely populated city.
The phrase, "the right of the people," appears elsewhere in the Constitution, where it unquestionably refers to individuals. Why should it mean something different here?
Because this amendment is unique in that it explicitly ties the right to a collective civic institution, namely the militia, rather than to individual self-defense.
Why does the law prohibit the use of a functional firearm in the home, where self-defense is most immediate and most personal?
The law regulates the manner in which firearms are kept, not their existence, and those regulations are justified by compelling public safety concerns.
Why should courts prevent legislatures from balancing gun ownership against the demonstrable risks of gun violence?
The Second Amendment protects an individual right. The phrase, "the right of the people," means individuals just as it does elsewhere in the Constitution. The core of that right is self-defense, and the place where self-defense matters most is the home. A ban on handguns is not a regulation of the right, it is a destruction of the right. A requirement that firearms be kept inoperable makes lawful self-defense impossible.
Is the handgun the most commonly chosen weapon for self-defense?
Yes, Mr. Chief Justice. That is precisely why banning it effectively bans the exercise of the right itself.
What role, then, does the militia language play in your interpretation?
It explains one reason the framers valued the right, but it does not limit who holds it.
The constitutional text controls our analysis. The phrase, "the right of the people," refers to individual rights throughout the Constitution, and there is no justification for treating it differently here. The militia clause announces a purpose, but it does not restrict the scope of the right. The Constitution has always treated the home as a place where liberty interests receive heightened protection. A law that eliminates the ability to defend oneself in the home crosses a constitutional boundary.
The right to keep and bear arms existed before the Constitution. The Second Amendment recognizes a pre-existing right rather than creating a new one.
This case is not about abolishing gun regulation. It is about identifying the core of a constitutional right and preventing government from legislating that core out of existence.
The majority's approach misunderstands history. The Second Amendment was adopted to preserve state militias, not to constitutionalize private gun ownership for personal purposes.
Even fundamental rights must operate in the real world. Courts should balance constitutional protections against the real and serious consequences of gun violence.
Justice Scalia has the opinion of the court.
The Second Amendment protects an individual right to keep and bear arms. The phrase, the right of the people, refers to individual citizens, not to states. The prefatory clause concerning a well-regulated militia announces a purpose, but it does not limit the operative guarantee. Historical evidence demonstrates that the right to keep and bear arms existed prior to the Constitution and was understood to include the right of self-defense. The core lawful purpose of the Second Amendment is self-defense, particularly defense of one's home. A complete ban on handguns, which are the most commonly chosen firearm for lawful self-defense, violates the Second Amendment. Likewise, a requirement that lawful firearms be rendered inoperable in the home makes self-defense impossible and is unconstitutional. The right secured by the Second Amendment is not unlimited. Long-standing prohibitions on the possession of firearms by felons and the mentally ill, restrictions on firearms in sensitive places, and conditions on the commercial sale of arms remain presumptively lawful. The judgment of the Court of Appeals is affirmed.
The Second Amendment was adopted to protect the ability of states to maintain well-regulated militias. It was not intended to create a constitutional right for individuals to possess firearms for private purposes. The Court's decision disregards the text, structure, and history of the amendment. For more than 2 centuries, courts and legislatures understood the Second Amendment as addressing military organization rather than personal gun ownership. The Constitution leaves decisions about firearm regulation to elected legislatures. Today's decision substitutes the judgment of this court for the considered judgments of democratic institutions. I respectfully dissent.
Even assuming that the Second Amendment protects an individual right, that right should be subject to interest balancing. Courts routinely weigh constitutional rights against compelling governmental interests. The District of Columbia enacted its law in response to extraordinary levels of gun violence. The majority's rigid approach denies legislatures the flexibility necessary to protect public safety. The Constitution does not require the result reached by the court today. I respectfully dissent.
D.C. versus Heller permanently transformed the Second Amendment from a rarely litigated provision into a powerful and enforceable individual right. At the same time, the decision placed the Supreme Court at the center of one of the nation's most divisive policy debates and limited the ability of legislatures to respond to gun violence through democratic means. It is hard to ignore the fact that Heller raises difficult questions about how constitutional rights coexist with public safety and democratic governance. However, every modern Second Amendment case begins right here at D.C. versus Heller.